This week on the Writers Detective Bureau, Diamond Jubilee, Grand Juries, and Cultural Diversity. I'm Adam Richardson, and this is the Writers Detective Bureau. This is episode number 28 of the Writers Detective Bureau, the podcast dedicated to helping authors and screenwriters write professional quality, crime-related fiction. Happy birthday to you. Happy birthday to you. Happy birthday, dear Mom. Happy birthday to you. The number one fan of this podcast is none other than my mother. She's celebrating her Diamond Jubilee, let's call it, this Tuesday. So I wanted to not only publicly embarrass myself through singing, but I wanted to wish you, Mom, a very happy birthday. Thank you for listening, and thank you for your undying support. I could not have asked for a more loving and supportive mom. I love you, and happy birthday. So speaking of thank yous, I want to thank Gold Shield patron Deborah Dunbar from DeborahDunbar.com and Coffee Club patrons Joan Raymond, Natasha Badgema, Natalie Borelli, Joe Trent, Siobhan Pope, Leah Cutter, Ryan Kinmill, Richard Phillips, Robin Lyons, Jean DeRoche, Craig Kingsman, and Kate Wagner. Your support keeps the lights on in the Bureau. Please support all of these awesome authors by visiting their author websites and reading their books. You can find links to their websites in the show notes at writersdetective.com/28. Now, if you have your own author business, consider joining Patreon. It's free for you, and it allows your readers to support you financially through monthly micropayments. Give your fans a chance to show their support by creating your own Patreon account right now. To learn more, visit writersdetective.com/Patreon. In 1962, Noah Weinstein and William J. Shaw wrote, "A grand jury is a short-lived, representative, non-political body of citizens functioning without hope of personal aggrandizement. It comes from the citizens at large and soon disappears into its anonymity without individual recognition or personal reward." Today, we're talking about grand juries. Now, in the United States, a federal grand jury consists of 16 to 23 people, and it's an important tool that allows prosecutors to issue subpoenas that require people to produce documents and other evidence, and subpoenas can also be used to compel people to testify under oath before a grand jury. There are also grand juries at the county level in many states, so those grand juries investigate state crimes, not federal ones, and those are made up of either 11, 19, or 23 people, depending on the population of the county, or at least that's the way it works in California. For criminal law, grand juries are tools used as part of criminal procedure to bring an indictment against the defendant. Now, this may be surprising to some of you listening outside of the United States, as grand juries have been abolished or are rarely used throughout the rest of the English-speaking world. Now, if you're a fan of true crime, or have been following the Mueller investigation, you have undoubtedly heard the term indictment before. It's important to understand that indictment, or being indicted, means that the criminal charge stems from a grand jury proceeding. Back in episode 24, we talked about the complaint process and going from arraignment to the preliminary hearing to a jury trial, which is how most on-view arrests are prosecuted, like when a police officer sees a criminal commit a crime and arrests them on the spot, or when a detective obtains an arrest warrant. The arrest goes through the complaint process to start the prosecution ball rolling. The complaint process does not typically involve a grand jury, so it's important to note as an author or screenwriter using legal terminology that the term indictment is only used when we're talking about a grand jury. I should also add that the only way to charge someone criminally in federal court is through a federal grand jury. The Fifth Amendment to the United States Constitution states, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury." So at the federal level, prosecutions start with a grand jury proceeding. The purpose of the grand jury is not to determine guilt or innocence, but to decide whether there is probable cause to prosecute someone for a felony crime. Now, if this sounds familiar, it's because a preliminary hearing serves a very similar purpose. For California grand juries, meaning not federal, and talking about ones that I have used, or dealt with. In some counties, the regular grand jury issues indictments. In others, the Superior Court, at the request of the district attorney, impanels a separate criminal grand jury to hear evidence in support of an indictment. Now, there may be a civil grand jury impaneled as well in that county. Grand juries have existed in this state since the adoption of California's original constitution around the year 1850, and the state constitution requires that a grand jury be drawn and summoned at least once a year in each county. And in addition to the state constitution, the California Penal Code and California Government Code cover how grand juries are operated throughout the state. How grand jury works is much more relaxed than normal courtroom proceedings. There's no judge present, and frequently there are no lawyers except for the prosecutor. And the prosecutor explains the law to the jury and works with them to gather evidence and hear testimony. In a normal courtroom, rules of evidence, exhibits, and other testimony must adhere to strict rules before admission. But in a grand jury, they have broad power to see and hear almost anything they'd like. When a witness testifies under oath before a grand jury, no one else is permitted to be present other than the prosecutor and the grand jurors. The witness is not allowed to have a lawyer present, and the normal rules of evidence that limit questioning in a trial do not apply to the grand jury. And unlike most trials, grand jury proceedings are kept pretty much in secret, and it serves two reasons. One, it encourages witnesses to freely speak without fear of retaliation, and also it protects the defendant's reputation in case the grand jury does not indict them, so it doesn't injure their reputation. If the grand jury determines there's sufficient evidence presented by the prosecution to believe that the accused person probably committed a crime, in other words, probable cause, then the grand jury returns what is called a true bill. A true bill is the written decision of a grand jury, and it's signed by the grand jury's foreperson. So if the grand jury returns a true bill, the accused person is indicted for the crime. If the grand jury returns a no bill, then the accused person is not indicted. And just as I mentioned, since the proceedings are held in secret, the public is none the wiser. It's also important to note that grand juries need a supermajority for an indictment, not a unanimous decision like a normal jury. The percentage for that supermajority can differ between jurisdictions, whether that's 2/3 or a 3/4 majority, but not being unanimous is unique to grand juries. If the grand jury chooses to indict, this often takes the place of a preliminary hearing. So it's possible for the indictment to lead to an arraignment of the defendant and then directly to a jury trial. So why would a prosecutor choose to impanel a grand jury rather than go the complaint process? Now, I'm talking about the state level here, since we've already discussed that a grand jury is pretty much mandatory for a federal case. So there are a variety of reasons why the prosecutor may choose the grand jury route, and it's usually a strategic decision. First, it's held in secret. This means the accused doesn't know they're facing charges yet. Second, it protects the identities and testimony of witnesses for longer. They'll probably have to identify themselves and testify at the jury trial, but it delays revealing who's testifying and what's being said as testimony. And third, it delays having to provide the defense attorney discovery. Now, discovery is the process of turning over evidence to the other side for prosecution and defense in a timely manner. The clock on providing evidence to the defense doesn't start until the accused person has been arraigned. That's what starts what is called the discovery period. So in this case, time is on the side of the prosecutor when we're using a grand jury. This can be a really important factor. Let's say we're working on a large-scale conspiracy where there are multiple defendants and the investigators are relying on evidence obtained through a wiretap recording. Let's say it's a series of murders committed by a criminal street gang, and the prosecutor is relying upon hours of recorded telephone calls between the conspirators to prove the case. What if it's hundreds of hours? If you were going through the complaint process for arresting these suspects, you would need to have copies of those audio recordings along with the transcripts of hours upon hours of recordings. They'd need to be ready to go for discovery almost immediately. So what do I mean by this? Remember when I said discovery must be done within a timely manner? So let's say we arrest the suspects and they're arraigned within 48 hours. So at the arraignment, the judge is going to set a date for the preliminary hearing after hearing that the suspects plead not guilty and they get their attorneys. So remember, we're talking about the complaint process here, not using a grand jury. A smart defense attorney will refuse to waive time. This means the defense is using their Sixth Amendment right to a speedy trial, or in other words, their right to a preliminary hearing within 10 court days of arraignment for California, or up to 30 court days in other states. So since a prelim could be potentially 10 days away, this is when the discovery period starts. The prosecutor will need to deliver the audio recordings and transcripts they intend to present as evidence at the prelim pretty much immediately. This may be impossible if the prosecutor has hundreds of hours of audio recordings to still have transcribed. So if that is your key piece of evidence and it isn't delivered to the defense as part of the discovery period, the prosecutor might be out of luck when it comes time to getting it entered as evidence at the prelim. So to avoid the time crunch and discovery altogether, the prosecutor will likely opt for a grand jury proceeding. This can also protect the existence of a wiretap investigation in the first place. So there's no discovery because there isn't a defendant nor a defense attorney present during the grand jury proceeding, much less aware of the proceedings themselves. So one important note about the prosecutor's role in a grand jury proceeding is that the prosecutor must also act in the interest of the defense to a certain extent, meaning the prosecutor must also ask questions that could lead to exculpatory evidence. But as a New York judge turned convict once said, a grand jury would indict a ham sandwich. I urge you to learn more about the roles of grand jurors wherever your story takes place. It could lead to an interesting character, a character point of view, or even a full-blown story. If you live in the United States, you should consider becoming a grand juror. Unlike typical juries, which are also known as petit juries, like small, petite, petit juries, you can serve up to 1 year on a grand jury, usually in 1 or 2 day increments per month. Most counties accept applications to become a grand juror, in addition to filling those seats with a regular jury summons process. In addition to returning true bills or no bills in criminal cases, local grand juries also act as an independent investigative watchdog, a form of check and balance against local government. Grand juries can investigate whatever they want, whether that's jail overcrowding or a corrupt mayor. It's a great way to get involved in your community government rather anonymously, but in a very meaningful way. This week's next question comes from Leah Cutter, and you can find her at leahcutter.com, and that's Leah with an H at the end. And Leah asks, how much training does a modern officer receive in regards to gender sensitivity? For example, what if a male detective was interviewing a murder suspect who did not present as either male or female, and who used gender-neutral pronouns? Would it bother the detective? Or would he have received training in order to deal with this type of situation? This is modern-day Seattle. Thank you. I love your show. I'm going to a mystery writers workshop later this year and plan on telling all the writers there to subscribe to you, Leah. Thank you so much, Leah. That was very nice of you to say. So let's go back to my police academy training days. I attended the police academy in California in the mid-1990s, which for some of us seems like yesterday, but by law enforcement standards, I've found that I've suddenly been classified in the dinosaur category. Oh, the joys of retirement in our 50s. So now that I'm the old guy, anyway, in the police academy in the 1990s, I received 40 hours of cultural diversity training. The concept of the course was to cover all types of diversity that we will encounter out in the real world, whether that meant victims, suspects and witnesses, or even coworkers. So the class literally consisted of meeting people from various cultures, different races, sexual orientations, that kind of thing. And we also talked about stereotypes, where they come from, how they can lead to or confirm bias, that kind of thing. So you might be thinking that 40 hours isn't much time for that kind of training. But to put it in perspective, we only spent 24 hours on officer survival will to live training. So that's just an example of the training priorities that existed in California over 20 years ago. So Seattle is just as progressive, if not more so, than California when it comes to peace officer trainings. So I would bet dollars to donuts that the police officers in Seattle have had training on gender sensitivity. And very likely this happened in their basic police academy as well as part of ongoing professional training. So I should mention that it's far more likely that the younger officers would have received more training in the academy than someone that's been on the job for a few decades. And it's also important to recognize that when you're writing modern stories, that the older, or let's call us more experienced characters, are a lot younger than we have a tendency to really think. So to use me as an example, I'm in my mid-40s and I'm about 5 years away from being eligible to retire with my full pension. But as old as that makes me sound, I was actually in high school when Rodney King was pulled over by the LAPD. And I was in my first years of college when the verdict from that trial resulted in the LA riots. Now, my generation, that forgotten Generation X generation, was that new generation of kinder, gentler, community-oriented policing officers. So most of the old school cops, many of whom also served in Vietnam, the ones that we have a tendency to think of as a caricature, are long since retired and living the good life, very likely up in Idaho somewhere. So anyway, back to Leah's question. Leah also asked whether a murder suspect that uses gender-neutral pronouns would bother the detective. As a practical matter, in conducting any interview, we have a natural tendency to use the pronoun you most often. Where were you? What did you see? What did you do? So it's easy to avoid any pitfalls when it comes to gender sensitivity when talking directly to someone. As for the detective being bothered, I seriously doubt it. I mean, we talk to people from all walks of life. And if I was the detective, I would use that understanding of gender sensitivity to help build rapport. Anytime someone feels marginalized in society, that's the quickest way to get them to open up, is to feel seen and heard. So that's what I'm going to try to do. I'm not there to pass judgment on gender, race, religion, or even your chosen hobby. The faster and clearer that I can get that across, the more likely the person in that chair across from me is going to open up. So if it were me, I would respectfully ask the person how they'd like me to address them. Showing that respect will get me miles further down the road in my murder investigation. And if gender sensitivity played a part in the crime, by being open and non-judgmental and able to talk about it without coming across negatively, that may really have an impact when it comes to cracking open the motive of the crime. Thank you for the question, Leah. I hope this helps your story. You can find Leah's work at leahcutter.com. Thank you so much for listening this week. We've already surpassed 6,000 downloads on this little podcast. 10,000 is not too far away. So thank you for your support. Thank you for sharing this podcast with your writing friends. I will talk to you next week. Thanks again for listening. Write well. Happy birthday, Mom.